Hello everyone, myself VAIBHAV and I am a part of LEXIS and Company as a legal intern. Today I am going to talk about principles of insurance under insurance law. Let's start with what is insurance. Insurance may be described as a social device to reduce or eliminate risk of life and property. Under the plan of insurance, a large number of people associate themselves by sharing risk attached to individual. We can say that insurance is actually a contract between two parties where one party called insurer undertakes in exchange for a fixed sum called premium to pay the other party on happening of a certain event. With the help of insurance, large number of people exposed to similar risk make contribution to a common fund out of which the losses suffered by unfortunate few due to accidental event are made good. So, insurance is a contract in which a sum of money is paid by the assured in consideration of the insurers incurring the risk of paying larger sum upon a given contingency. There are 7 principles of insurance which are number 1, principle of vermä fidei, that is utmost good faith. Vermä fidei is a Latin phrase, or in simple English word, the principle of utmost good faith is a very basic and first primary principle of insurance. This principle says the insurance contract must be signed by both the party, that is insurer and insured, is an absolute good faith or belief or trust. In this principle, the person getting insured must willingly disclose and surrender to the insurer his complete true information regarding the subject matter of insurance. The insurer liability get void if any fact about the subject matter of insurance are either hidden, omitted, falsified or presented in a wrong manner by the insured. Second principle is principle of insurable interest, which means a relation between the insured and the event insured against, such that occurrence of the event will cause substantial loss or injury of some kind to the insured. This principle states that person getting insured must have insurable interest in the object of insurance. A person has an insurable interest when the physical existence of the insured object gives him some gain, but its non-consistent existence will give him a loss. In simple words, the insured person must suffer some financial loss by the damage of the insured object. For example, the owner of a taxi cab has insurable interest in the taxi cab because he is getting income from it, but if he sells it, he will not have an insurable interest left in that taxi cab. From the example, we can conclude that ownership plays a vital role in evaluating insurable interest. Now let's talk about third principle, that is principle of indemnity. As we have read in contract law about indemnity, as in indemnity means security, protection and compensation given against damages, loss or injury. According to the principle, an insurance contract is signed only for getting protection against unpredicted financial loss arising due to future uncertainties. Insurance contract is not made for making profit, else its sole purpose is to give compensation in any case of damages or loss. This principle states that the insurance contract is basically to indemnify the insured person in case of any loss faced by him. However, in case of life insurance, the principle of indemnity does not apply because the value of human life cannot be measured in terms of money. Now coming to the fourth principle, that is principle of contribution, which is a corollary of the principle of indemnity. It applies to all the contract of indemnity if the insured has taken out more than one policy on the same subject matter. According to this principle, the insured can claim the compensation only to the extent of actual loss, either from all the insurers or from any one insurer. If one insurer pay full compensation, then that insurer can claim proportionate claim from other insurer. For example, if a house is insured with company X for rupees 5,000 and with company Y for rupees 10,000, and the damages amount to rupees 1,200 occurs, company X will apparently be liable to contribute rupees 400 and company Y rupees 800 respectively. So if the insured claim full amount of compensation from one insurer, then he cannot claim the same compensation from other insurers and make a profit. Secondly, if one insurance company pay the full compensation, then it can recover the proportionate contribution from the other insurance company. Now let's talk about another principle, which is principle of subrogation. Subrogation means substituting one creditor for another. This principle is an extension and another outcome of the principle of indemnity. It also applies to all the contract of indemnity. It is generally applicable to the contract of fire insurance and marine insurance. According to this principle, when the insured is compensated for the losses due to damages to his insured property, then the ownership right of such property shifts to the insurer. For example, Mr. A insures his house for rupees 1 crore. The house is totally destroyed by the negligence of his neighbor Mr. B. The insurance company shall settle the claim of Mr. A for rupees 1 crore. At the same time, it can file a lawsuit against Mr. B for rupees 1.2 crore as per the market value of the house. If insurance company win the case and collect rupees 1.2 crore, then the insurance company will retain 1 crore as they already paid to Mr. A plus other expenses which they incurred in the court, which they incurred in the suit, and the balance amount will be given to the Mr. John, that is the insured. Another principle is principle of loss minimization. According to this principle, insured must always try his level best to minimize the loss of his insured property in case of uncertain event like a fire, outbreak or a blast, etc. The insured must take all possible measures and necessary steps to control and reduce the losses in a scenario. Basically, this principle state that the insured person must take possible measures and steps to control the losses. He must not remain inactive and think about why should I worry, I have insured my this and this and this and this. He has to be active in that case. The last principle of insurance is principle of causa proxima, that is nearest cause. Principle of causa proxima, or in simple English word, principle of proximate, that is nearest cause, means when a person makes a loss which is caused by more than one causes, the proximate or the nearest or the closest cause should be taken into consideration. The closest cause should be taken into consideration to decide the liability of the insurer. This principle states that to find out whether the insurer is liable for the loss or not, the proximate and the not remote must be looked into. For example, a cargo ship's base was punctured due to rat, and so sea water entered and cargo was damaged. Here are two causes for the damage of the cargo ship. Number one, getting punctured because of rat, and sea water entering ship through puncture. The risk of sea water is insured, but the first cause is not. The nearest cause of damage is sea water, which is insured, and therefore the insurer must pay the compensation. However, in case of life insurance, the principle of causa proxima does not apply. Whatever may be the reason of death, natural or unnatural, the insurer is liable to pay the amount of insurance. I hope you like the video. Thank you.